already said my name is John Borofsky, and I am the chair of the Eugene Planning Commission. To start, I'd like each of the planning commissioners to introduce themselves.
Brianna Nicolalo, Vice Chair.
Stephen Baker, Planning Commissioner.
John Jaworski, Planning Commissioner.
Elliot Becker, Planning Commissioner.
Kristen Taylor, Planning Commissioner.
And then we also will be having Commissioner Randall by teleconference. Are you there, Bill?
Yes, I am. So, Bill Randall, Planning Commissioner.
Very good, thank you. We also have some staff here that I'd like to have them introduce themselves as well.
Sure. Alyssa Hanson with the Planning Division.
Althea Sullivan, Assistant Planner.
Lauren Summers, City Attorney's Office.
Senior Planner.
And Robin Hostig, Planning
Thank you. I'd like to take a moment to explain who the Planning Commission is and our role. We're unpaid volunteers appointed by the City of Eugene City Council to 4-year terms on the commission. We all live and work in Eugene, like many of you do. We directly advise our City Council on all matters related to land use, and we are also tasked with making certain land use decisions on behalf of our City Council. We're responsible for upholding the laws of our city and our state and the policies of our City Council, and of course at the same time we are responsible to everyone that lives and works in Eugene. We are at-large members, which means we have to consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We are also human, which means that each one of us has personal views that make us who we are. But as planning commissioners, we are committed to balancing all of our needs as a community and making the best decisions we possibly can based on our policies and our laws for us and future generations. That can be pretty tough to do, and we know not everyone will agree with every decision we make. So as we proceed today, we want you to know up front that we are listening to and that we care deeply about you and our community. We listen carefully and hear your concerns and your hopes. Even though we may or may not be able to do what you want, you will be heard, and we will strive to make the best decisions possible. Oh, geez. Sorry about this, folks, but we will begin with a presentation from staff and then open up the public hearing. If anyone in the audience would like to speak, please fill out a request to speak form and bring it forward to the staff. Those are the green forms that are back there by the door. Once the public hearing is open, speakers will be called in the following order: the applicant and those in support of the zone change application. Second is those with a neutral position, and third is the appellant and those opposed to the application. The Planning Commission's decision will be the final city decision on this matter. As we have until November 9th to reach a decision on this application, we will begin deliberations and possibly take action this evening. If there are any further appeals after our decision, they will go to the State Land Use Board of Appeals. Some of the terms we have to use are legalistic, so I'll try to explain the requirements in plain English the best I can. Since this is an appeal hearing, there are unique procedures which we are legally required to follow. The decision of the Planning Commission on this appeal is considered quasi-judicial, so we will use quasi-judicial format for this public hearing. This means we have certain orders of speakers that we need to follow, and there are certain rules or criteria that our decision must be based on. The purpose of tonight's hearing is to receive relevant testimony on the appeal issue before us. I want to remind everyone that your testimony must be directed toward the issues identified in the appeal statement and the applicable approval criteria from the Eugene City Code. No new evidence can be accepted by the Planning Commission, and we can only accept testimony related to evidence that is already in the record. What this means is that you should be testifying about the materials and information already presented to the hearings official in the first public hearing process. Whether or not you think the hearings official made a mistake based on the approval criteria for the zone change and the evidence he had at the time. I am also supposed to remind everyone that failure to raise an issue with sufficient specificity to allow the Planning Commission and parties to respond will preclude future appeals on that issue. In other words, now is your opportunity to raise issues as clearly as you can so that the city and other parties can address them. Before we begin, the Eugene City Code also requires that planning commissioners disclose any conflicts of interest, ex parte contacts, biases, or abstentions. In quasi-judicial proceedings like these, the parties are entitled to an impartial or neutral decision maker. To ensure this fair consideration of the Eugene Code and the Planning Commission's rules, attempt to limit ex parte communications or contacts between the party and the decision maker outside of the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they have had about this application outside of the public process. The planning commissioners must also disclose any potential conflicts of interest, that is, whether the decision they are about to make could or would result in a personal, financial gain to themselves, their businesses, or a member of their households. Finally, a planning commissioner cannot participate if he or she is biased. That is, for whatever reason, he or she is incapable of rendering an objective decision on this appeal. There are 2 emails that were provided in the agenda item summary that concern 2 commissioners and their conflicts of interest. I would like them to disclose these now. We'll start with Kristen Taylor.
I am the applicant's representative that prepared the application. So I am their hired planner through TBG Architects and Planners, where I currently work. So I have a conflict of interest.
Okay. And Commissioner Randall?
Yes, my architectural firm has been retained by RNS Management, LLC, to provide architectural services for the development that's the subject of the zone change application Z17-3. It's my understanding that the hearings official's decision on that application has been appealed to the Planning Commission, which is why everyone is here tonight. Therefore, pursuant to ORS 244.120, Eugene Code sections 2.333 and 9.7065, and the bylaws of the Eugene Planning Commission, I am declaring an actual conflict of interest with respect to this application, and I will not participate in any discussion or decisions by the Planning Commission regarding this application.
Well, that was really thorough. I am not going to participate either. Thank you.
Okay.
Commissioner Randall.
Okay. You're welcome.
Thank you. With that, yes.
I would just like to confirm for the record that I heard both Commissioner Randall and Commissioner Taylor declare actual conflicts of interest and say that they will not participate in any decision or action by the Planning Commission on this matter.
That is correct.
Great.
Yes.
Thank you.
Okay. At this time, Commissioner Taylor and Commissioner Randall, you are excused.
Thank you.
Thank you.
Do any other commissioners have a conflict of interest or ex parte conflict that they would like to disclose? Commissioner Jaworski.
Yes, I'm Commissioner John Jaworski, and I want to talk about an ex parte contact I had back in the spring of this year. I was asked by the chair of the Cal Young Neighborhood Association to go into one of their membership meetings on May 25th at the Sheldon Community Center. I went there to give a brief presentation and answer any questions that those memberships may have. I did not know what was on the agenda, and I wasn't really paying that much attention. However, during the meeting, there seemed to be some discussion of a zoning change. It wasn't clear to me because I was looking at my notes to speak. There were a couple of residents that made some comments. There was an elderly gentleman who stood up, who everybody knew, I didn't know, and he was either the owner or a developer or whatever, and he addressed some of those questions. And then that seemed to be that, and then I got up and did what I did at that particular meeting. I have not tracked anything since that time other than what's been provided to me by the city staff. I do not feel that I am biased in any way and feel that I can act to this particular appeal in a proper manner.
Staff, is that what we need to hear from him? Very good. Anybody else have any ex parte communications or conflicts of interest that they would like to disclose? Okay. Having that been said, we will now begin with a brief.
Oh, I'm sorry.
Oh, yes.
Commissioner Borowski. So because an ex parte contact has been disclosed, any person during his or her testimony has the right to rebut the substance of that ex parte communication. It sounds like there wasn't much substance that Commissioner Jaworski took away from that interaction. But the parties who are testifying tonight do have the right to speak to that if they so choose.
All right.
Thank you.
Thank you. Anything else that I need to do before the staff presentation? Okay, at this time we will have a brief presentation from staff, and then we will move on from there.
Thank you, Chair Borowski. Again, my name is Lauren Summers. I'm an assistant city attorney here with the City of Eugene. I appreciate that the commission has a lot to do tonight, so I'll try to be quick. But I thought that, especially since this is Commissioner Becker's first appeal hearing, and it's always a good idea for a little refresher, that I would go over a couple kind of high-level things before we get down into the nitty-gritty of the public hearing. So, as you all know, Planning Commission generally acts in one of two capacities, either a legislative capacity or a quasi-judicial capacity. When you're acting in your legislative capacity, that is when you are making recommendations to the City Council about land use code amendments, legislative matters. And in that capacity, it's fine for you to talk to your constituents. It's fine for you even to come to the table with kind of some preconceived ideas about what should happen with the legislation. In contrast, when you are acting in a quasi-judicial capacity, like tonight, you're being asked to act like a judge. And what that means is the parties to this appeal are entitled to a neutral, unbiased decision maker. So you are asked to look at only the materials that have been provided to you and to not come to the table with a preconceived idea about how things should go. You should be able to look at the relevant code criteria, at the appeal issues that have been presented to you, and at the record that is before you, and make a decision based on those things only. No individual fact-finding and no creation of your own appeal issues. So, as you know, there are some appeal issues. The appellant has identified 3. They are on pages, I think, 3 and 4 of your AIS, and they're also, the appeal statement is attached to the AIS as attachment C. The way that our code is set up in an on-the-record appeal, like you have here, where the hearings official, this land use application was submitted. It's a zone change application. Folks had opportunity to submit evidence and make arguments to the hearings official. Hearings official held a public hearing, looked at the relevant code criteria, looked at the evidence that had been presented and the arguments that had been made to him, and made a decision on whether to affirm or deny the application. In this case, he decided the application should be approved. There were some folks who disagreed with the hearings official's decision and filed an appeal. And the way our code is set up, when someone files an appeal, they have to identify the specific issues where they disagree with the hearings official. The appellant here has identified 3, and they're available in attachment C. So your role tonight as the appellate body is actually very narrow. What you're being asked to do is to look at the information the hearings official had, to look at only the appeal issues identified by the appellant, and to look at the relevant code criteria for a zone change, and to decide whether you agree with the hearings official's decision. Did the hearings official get it right? So that's kind of my by way of my quick overview. I also wanted to take a moment, excuse me, before we move into the public hearing, to give the Planning Commission the opportunity to address Commissioner Baker's email requesting that the Planning Commission review the entire Willackenzie area plan and the 1978, or the record for the 1978 rezoning of the property that's the subject of this application. I am bringing it to you as the commission because I think it's a decision the commission needs to make as a body. Commissioner Baker, did you want to?
I wanted to clarify. I wanted a copy of the Willackenzie area plan to better understand the context of the issue. It didn't mean that I would apply all of the applicable policies and recommendations, but I wanted access to that before this meeting.
Sure, I understand that.
And I haven't accessed that.
Right. So you've not been provided with those documents because that's a decision that the commission itself needs to make. Those documents are something that the commission has the authority to look at, but my recommendation to you is that you not. And that's true for a couple of reasons. The first is that, again, a reminder that the Planning Commission is generally limited to the evidence that was in front of the hearings official. And the hearings official in his decision was very clear that he looked at the evidence that was in the record, which did not include the entire Willackenzie area plan, nor did it include the entire record of the 1978 zone change application. There are portions of the Willackenzie area plan that are in the record, and Althea and I can help you locate them if that's something that you're interested in. I believe there are also portions of the 1978 zone change application in the record, and we can help you find those too if you find them, if you think that would be helpful. So kind of the first piece is the hearings official didn't look at the whole plan, didn't look at that whole record, so I recommend that you confine yourselves to the same evidence that the hearings official looked at. The second issue is we have the 3 appeal issues that have been identified by the appellant. Those are the 3 things that you're here to consider tonight. All of them relate to one particular policy in the Willackenzie area plan, which is in the record and is also in your AIS. And so we can help you identify that policy. But it seems to me that it's not necessary for the Planning Commission to review the entire Willackenzie area plan when all 3 appeal issues are related to that single policy that is already in the record. One other thing that I would say is that if the Planning Commission does decide to consider new evidence that was not before the hearings official, we have to think about reopening the record to allow the parties to respond to that evidence. Right now, well, not right now, our deadline to make this decision, the city's deadline is November 9th, which is 3 days from now. I don't believe that there's an adequate amount of time for the record to be reopened, the parties to make arguments, the Planning Commission to thoroughly consider those arguments and make a decision before November 9th. And that would also require scheduling a second meeting before November 9th to allow you to make that decision. So for all of those reasons, my recommendation is that you not consider the entire Willackenzie area plan or the 1978 zone change record. But I want to be clear that the ultimate decision is up to the Planning Commission.
Okay. Commissioner Baker?
I have to disagree with the legal counsel in this matter. All adopted refinement plans become part of essentially part of the comprehensive plan and the Eugene Code in Chapter 9, and none of those need to be dropped into the record to be reviewed or cited in public deliberations on an issue, and I think that's been well established by LUBA. So there's no reason to open the record to do that, but I want to make it noted that I was prevented from looking at this material by recommendations from staff, and that all of us received that email because we were all CC'd on it. So That causes me to be, it's a problem, because it's not that I would look at the entire plan, but I would read that plan to get the context for this one small policy that happens to be taken out of Chapter 9. I can give you the citing type, the place where it pulls from. But the Williams-Kenzie area plans and refinement plans in general have lots of information that backs up how that policy was determined, and what was the meaning of that you can't really get from a one or two sentences in Chapter 9.
Commissioner Jaworski.
I'm not as much detailed as Commissioner Baker there on what he has cited, but I did have an issue, and that was in looking at the particular policy so cited. I believe, and I don't want to get into deliberations now, but I believe the hearings official made a decision that particular policy was a policy to the city and had no reflection on land use. In order to make that determination, he had to look at something else in the plan, because the plan is an integrated plan. You don't look at one component part without the other. And I didn't know we weren't supposed to read this, because I've had a copy of this. I live in the Williams-Kenzie area. And if you read the introduction, it indicates that all of those component parts are part of an integrated plan, which also impacts land use, which he said did not. So I'm going to have a concern with this when we move on. And from when I read his decision, I could not determine whether or not he had read the plan or not, because he did not cite, I did not read the Williams-Kenzie plan, but only relied on this one policy. So I would have thought he would have done some background to make that decision. Just a comment.
Mr. Nicolello.
I think while I'm sympathetic to that concern, at the end of the day, it's the role of the applicant and the appellant to provide context for the decision-making body, the hearings official, and in this case now us. Therefore, we have to work with the context that they provided. If they felt that that was essential to our overall understanding of the plan and of the policy, I presume that they would have put it in the record. Since they did not do so, I do not think it's appropriate to take this in.
Commissioner Baker.
Again, I want to make the point that, I have to disagree with Commissioner Nicolello. Essentially, in all legal decisions I'm aware of, refinement plans are part of the Eugene Code, and they don't need to be dropped into the record to be reviewed as part of a quasi-judicial hearing. Now, again, if I'm in error, then we will find out very soon. But that's my understanding. So it doesn't, there's no reason to take notice of it. We are allowed to look at Chapter 9, the comprehensive plan, and all adopted refinement plans as part of our body of planning information that we can use in making decisions, plus the specifics of a particular case, in this case, the testimony and submissions for this particular case.
Commissioner Jaworski.
Yes, in response to Commissioner Nicolello, I understand what she is saying. However, if you look at the summary of issues, paragraph 1, it states, the appellant also ties transportation planning and policies in the Williams-Kenzie area plan to land use planning, arguing that there's a symbolic relationship. Okay, so it's there. They're saying that it's there, and so it is part of the record, although not detailed what section. Just a comment.
I don't think I follow that line of argument, Commissioner Jaworski.
Well, when we deliberate, we can talk about it.
We can. It'll be exciting.
Thank you.
But perhaps this would be a good point, though, for Ms. Summers to jump in.
So I'll just say a couple of things. First of all, Commissioner Baker, just to clarify, refinement plans are adopted into the comprehensive plan, but not specifically into the Eugene Code. I don't... And Commissioner Jaworski, if I read the hearings official's decision correctly, on page 2 of attachment D to your AIS, there's a heading that says documents considered by the hearings official. And he says, I have considered all of the documents in the planning file for the proposed zone change Z17-3 and the testimony provided at the public hearing. And my understanding, and planning staff can certainly correct me if I misunderstood, was that the planning file did not specifically contain the entire Williams-Kenzie area plan, nor did it contain the 1978 zone change record. If Planning Commission wants to look at the Williams-Kenzie area plan, you certainly can make that decision. My concern with the plan is not so much about the evidence outside the record. It's more about the appeal issues and the specificity of these appeal issues all relating to one policy in the plan that is already in the record. So I don't know that it's necessary to look at the entire Willett-Kenzie area plan, and I understand that you are under a tight timeline to make this decision. If you choose to open the record to look at the 1978 zone change record, I do believe that's new evidence, and I think that would require reopening the record here.
So at this point, I guess my question would be, what would be the appropriate time? Would it be after the public hearing is opened and closed to decide whether this issue as to whether we want to bring that in or not? Or would you like us to decide that before we open the public hearing? And if it's one or the other, I can steer the meeting either way.
I think you could do it either way. I would recommend doing it before the public hearing in case anyone has anything they want to say about
so
this item.
at this point then, I guess, Commissioner Baker, if you feel that there's a need to bring some of these items in, you can address that to the commission, and we can talk about what the implications of that would be as far as our deliberations and our timeline and the ability for people to enter and respond to other aspects of the record.
I just again want to make a point that when refinement plans are adopted part of the comprehensive plan, we don't have to drop a whole copy of the comprehensive plan into every public hearing to review that material. It's part of the code base that we operate under is the comprehensive plan in Chapter 9. So there's no reason to do that. Again, my main concern was that I didn't get a chance to review the Willett-Kenzie area plan, and I feel my decision-making may be compromised because of that. But I'm ready to go ahead because there's a short deadline. But I wanted to make it clear that I didn't think we got the right recommendation from our legal counsel.
Any other commissioners wish to speak to this?
I'm not interested in opening the whole plan. It just seems to me when you take a policy out of context, you should be able to look at what defines that policy, or where a reference to that policy is somewhere else. The same way when he cites here, well, I feel this is okay because it's consistent with the Metro Plan. Does that mean I can look at the whole Metro Plan because he referenced the Metro Plan and not a specific policy? That's where it gets confusing.
I understand, Commissioner Jaworski. As to that specific example, compliance with the Metro Plan is not an appeal issue, so that's not something that
No,
you
I
would be
understand, but
looking
he
at regardless.
says terminology like that, and that's what I'm talking about here. Because he says it's also consistent with the refinement plan. He didn't say it's consistent with the refinement plan, specifically policy 1.
Right.
He said it's consistent with the refinement plan.
But the
I just want to make
appeal
that clear,
issues
like I said.
identify specifically one policy, and because this is an on-the-record
I understand.
hearing,
Okay.
you are looking at that one policy to deal with those appeal issues.
So, hearing nobody making a motion that they would like to bring something more to the table, I'm going to move forward with the public hearing, and if the appellant or applicant wish to talk about this, we can hear it from them, but otherwise we're going to move forward with the public hearing unless I hear objection from the commission. Very well. So, I'm going to open the public hearing. Yes.
Do you have a little bit more staff?
I'm sorry.
Sorry.
Oh, yeah, sorry.
A tiny bit.
Yeah, that's great.
Thank you. So I'll start by reintroducing myself. My name's Althea Sullivan, Assistant Planner with the Planning Division. To everyone who's here tonight, thank you for taking your time this evening to come join us. For those of you that have called me today or over the past few months, thank you for taking the time to do that. I understand that it takes an effort to engage in the process, especially if you've never talked about land use in Eugene. There's a lot of information that you could look at, a lot of learning that could go with that. and just thank you for taking the time. I also understand that the process can be frustrating and legalistic. I know I've talked to a lot of people about traffic and about a traffic barrier and whether or not that fits within the current request for a zone change. So Lauren provided an overview of what we're doing this evening and the capacity in which the Planning Commission will act. I want to take a few minutes to remind everyone of what zoning is, what the application was for, and what was appealed from the hearings official's decision. I'm going to open up some slides that I presented at the hearing, so they are already in the record. So just starting, and this is very high level, just about what zoning is. In the city of Eugene, we have a metro plan, which some of you have been following Envision Eugene or have been a part of that and are aware that this Envision Eugene was adopted. However, when this application was submitted, we were still under the metro plan, and so we're still talking about that when I talk about the plan. Big picture, the Metro Plan is a policy document that has a designation map. I think the easiest way to think about the designation map is it's sort of like a blueprint for zoning. It has colors, it's where things go, and put together with the policies in the plan, it's intended to help guide land use decisions. Additionally, we have refinement plans, and those refinement plans are specific to an area. So in this case, the Willackenzie Area Plan is the plan that we're talking about. It's also very different from the South Hills Plan because it's a different part of town. The plan has policies in it as well as designations for what specific properties should or ought to be zoned. And then zoning is informed by both of those plans, and you can think of it as two-part. So the first part is a base zone. So examples of a base zone would be low-density residential, community commercial, high-density residential. And each of those zones has a section in Chapter 9 of the Eugene Code where it specifies particular uses. Some of the uses are what we would call allowed outright, and those you could come in and just get a building permit. So you wouldn't probably talk to planning, you would just show up at the counter for your building permit. Other uses are subject to review, and that review would be a land use application. And so assuming that you get your land use application approved, you could then apply for a building permit. The second part of zoning is overlay zones. Some properties have overlays, some do not. You could think about an overlay as potentially having two parts. One is a process piece, so an example would be a site review overlay, and even if the base zone allowed the property to come in for a building permit, if it had a site review overlay, the owner of the property who is looking to do something would potentially need to seek a land use approval no matter what, even if the table says their use is allowed. The other thing that can be part of an overlay zone is density. So the density for a specific property could be capped at so many units per acre. So going to the applicant's request, I just wanted to show everyone where the property is. This is Eugene. That little star is roughly over the area of the property. And then this red outline here is over the property. And then this zoning map only shows the base zones. So the property here is in red, and a portion of the property is zoned general office, so that's the GO. The top piece here is zoned medium density residential. And so the property, I don't know where my mouse went, there it is. So the property is split zoned, a portion is zoned each, and each of those zones have an overlay. So for the medium density portion, They have a planned unit development overlay, which is a process piece where they would be required to go through a planned unit development, be it one house or be it something else. And then the general, and it also has a 10 units per acre overlay, so they would need to come in exactly at 10 units per acre for density. And then the general office portion has the planned unit development overlay, which again is a process piece. The applicant requested a zone change, so that's just the portions of the property so it's 1.25 acres medium density with the overlay. There's 3.54 acres general office, and they're just requesting to lift both overlays from the property. As Lauren mentioned, the hearings official made a decision, and then an appeal was filed. So the appellants had 3 points to their appeal, all 3 of which appear to relate to a specific zone change approval criterion. That was Eugene Code 9.88652, which has to do with the Willackenzie area plan. And just for all of us, I copied these directly from the applicant's appeal statement and am putting them up there. It's up to you all if you want them left there during the public hearing, or I can pull them down. But there are the 3 statements, and then there's also further argument in the written statement from the appellant about each of those statements. So they further articulate the point, but those are just their general 3 points. I will mention that we originally had a hearing scheduled to hear this appeal in August, so that was a few months ago, and that we were asked by the applicant and the appellant to not hold the hearing. So we didn't hold the hearing. But at this point, we need to make a decision by Thursday of this week, and so we're here holding the hearing. I also just want to remind everyone here tonight that the appellant did file the appeal. It is their appeal, and so they can speak to it. They could also choose to pull the appeal if they wanted to. It is entirely up to them. I know that some people are here because they received a notice. We keep folks that previously participated in the hearing's official decision on our notice list. And you may have something to say about the appeal statements, but just a reminder that it is the appellant's appeal. Sorry about that. If you do speak tonight, it's easiest if you can let us know which appeal statement you are addressing and place your comments within that to the best that you can. And then I also want to mention that I did receive 2 additional pieces of testimony that are not included in the AIS. I received an email as well as a letter that was delivered this afternoon. Those are in front of each of the commissioners. And that's all I have to say.
Okay. Commissioner Baker.
I was just going to suggest that for the audience, maybe if you could go back to the slide of the zoning and describe what the height limits and the density allowed are in the base zone and then the base zone with the overlay, just so people would be familiar with that. That comes right out of the code. That doesn't need to be dropped into the record.
I'm happy to
I can cite the geo height requirements in the code if you want me to, but I think that that's ridiculous. We have staff that can do that.
I'm happy to. I'd like to be respectful of everyone's time here tonight, so I don't want to. I know there's people who are maybe waiting to get home. So I'm happy to do that briefly, but I will keep it brief. And during deliberations, I'm happy to further talk about that. Let me see if I can go back here.
Yeah, I'm fine. I can wait till deliberation to ask you the same question. So, if you'd rather me do that.
It doesn't matter to me at all. So
Let's wait to deliberations. I would like to get this hearing started. Anything else from staff at this point before I open the public hearing? Got to figure out who's got the hot mic. All right. At this point, I'm going to open the public hearing. Before we open the public hearing, I want to go over a few procedural items. As I mentioned before, we have until November 9th to make this decision, which is Thursday. For this reason, staff has reached out to the applicant and the appellant to discuss time limits. It's my understanding that both parties have agreed to a 30-minute time limit. I will also ask that individuals not affiliated with either party do their best to keep their testimony to approximately 3 minutes, to allow us sufficient time this evening to carefully consider the issues before us. Now, I've opened the public hearing. If anybody in the audience would like to speak and you have not done so already, please fill out a request to speak form and bring it forward to staff. Give your name, address, before beginning your public testimony. And we're going to start with the applicant, then those with a neutral position, the appellant, and then those opposed to the application, then staff comments, and then the applicant's final rebuttal is the form we're going to go in. So, with that said, I would like to call the applicant up first, which would be Rob Bennett. Or do you want your attorney to go first?
Okay.
You want the attorney to get the 30 minutes and then you come up after that? Okay. So then it's Michael Reeder, I believe.
Chair, Commissioners, good evening. My name is Mike Reeder. I'm with the law firm Arnold Gallagher here in Eugene. I represent the applicants in this zone change and represented the applicants at the hearings official level. And I'm here tonight to do a couple of things. We're going to walk and chew gum at the same time. The first thing that we'd like to do is establish timeframes. It's our understanding that the state law, according to the research done by staff, state law actually allows for additional time for the Planning Commission to make a determination on this matter, that you do not have to deliberate and make a decision tonight. If I'm incorrect, please let me know. If you need an affirmation from either party, I think we can grant that.
I think, Mr. Reeder, if the applicant is willing to offer an extension, that time is available, but it's up to the applicant.
Yes, so we would like to offer that time extension to the Planning Commission to make a final decision, and we grant the Planning Commission, we can grant the Planning Commission a certain number of days, and I'll need to confer with my client to figure out exactly what that is. The reason why we would do that is for a couple of things. One is we want the best decision made should a decision need to be made. That's not a foregone conclusion, as you may infer from the continued extensions. The parties are in negotiation and hope to have a private settlement wherein your decision would be, the need to make a decision would be obviated. So the first thing that I want to do is I want to thank the Planning Commission. I realize that you're volunteers. You volunteer your time on behalf of the community. And it may be frustrating for you to have a public hearing where it may not come to fruition because the parties are able to come to a resolution before your decision is required. So thank you for being here, for hearing testimony, hearing the neighbors, and hearing us. And I'll let the appellants speak to that issue as well. So, like I said, we're going to walk and chew gum at the same time, meaning we're hopeful that we can come to a private resolution settlement without you having to make a decision. But in the case that you need to make a decision, we are going to present our case in chief. Okay? Another preliminary matter, heard a lot of discussion about whether or not we can consider the Willikinzie area plan in its entirety, in its substance. Well, I'm not going to throw myself into the thick of that debate, although I will tell you that I brought a copy of the entire Willikinzie area plan and can make that available to any commissioner who wishes to see that. As the applicant, we have no problem with the Planning Commission actually referring to provisions of the Willikinzie area plan that are relevant to this appeal. And I agree with the commissioners that talked about the context of the Willikinzie area plan. And one of the reasons is because the Willikinzie area plan has defined terms. And those defined terms are found in the beginning of the Willikinzie area plan. And so it's helpful for you as a decision maker to understand the context of the Willikinzie area plan. And those provisions, that specific provision that was provided to you and cited by the appellants. So that being said, I agree with the city attorney that we are in this appeals hearing, we are limited to the precise issues raised by the appellants. So to that extent, when you're looking at the provisions of the Willikinzie area plan, they need to be related to the actual appeal statements. So for instance, if you're looking through the Willikinzie area plan and you see a policy or a proposed action that you think may have bearing on this actual application, if it wasn't raised by the appellants, then you are limited to referring to those provisions. Okay. So again, I'd like to thank staff. I thank the Planning Commission, but also like to thank staff. This is a complicated matter. There's mostly issues of law rather than issues of fact, which can sometimes be a complicating factor. But thankfully, that's why you have a hearings official who's a trained land use attorney who was able to navigate these legal issues, and we believe that he did so correctly. So we ask that the Planning Commission, should you be asked to ultimately decide, that you affirm the hearings official in his decision in its entirety. There's a couple of basic issues that I want to run by, some of which have already been run through by staff, but just be cognizant of the fact that we're not asking for a zone change that would change the base zoning of the property. We're simply asking for 2 overlays to be removed from the property, overlays that we believe are anachronistic. They are no longer relevant in 2017. We'll discuss in detail the issue that concerns the neighbors the most, which is the barrier that prevents cut-through traffic in that area. And we'll talk about the Willikinzie area plan. So the sole issue that's before you, it's broken up essentially into 3 appeal statements, but essentially the sole issue is whether or not the hearings official erred in removing the planned unit development PD overlay zone that applies to the entire subject property. Now, I told you we asked for 2 removals. One is the 10 unit per acre minimum on the R2 property. There was no objection to that, and this appeal is not there's no issue in this appeal regarding that overlay zone that was removed by the hearings official. The remaining issue is the PD overlay. Preliminarily, it should be understood that the hearings official did understand the issue that's before you tonight. The hearings official was well aware of the argument that pass-through traffic was a concern, that the planning, the PD overlay was a concern to the neighbors. So I want you to be, when you read the hearings official decision, it's clear that the hearings official understood that argument. Before I go into the minutia of the argument and responding to the appeals issues in detail, I want to make 3 things clear for the Planning Commission and as well as to the audience. And I'm reiterating what we said at the hearings official stage. The applicants have made the following 3 commitments. Like I said, you'll hear testimony today that the removal of the traffic barrier is a problem for folks. However, we are not proposing to remove the traffic barrier. We have not proposed that in the past. We don't intend to in the future. However, as the hearings official stated, the zone change application has nothing to do with the barrier. But be that as it may, the applicants are committed to having the barrier remain. We don't want it removed. It's simply not an issue for us. Number two, in spite of this fact, the applicants have committed not, in spite of the fact that it's not an issue relevant to the zone change, the applicants have committed not to seek the permanent removal of the barrier, except for the fact that it may be required to move the barrier for aesthetic purposes, not to remove it entirely, but to move it. And I don't think that's really an issue of contention, but I wanted to make that clear. The applicants do not want any cut-through traffic, none. They simply don't want it, and the applicants recognize that ultimately the decision to move or remove the barrier is a decision solely within the discretion of the City Public Works Department. In addition, the applicants, if they develop the property, intend to design the development in such a way as to discourage cut-through traffic. Remember, we don't want cut-through traffic, and so we fully intend, if we develop the property, to design it in such a way that people wanting to cut through the property, they'll be discouraged from doing so. So let's go to the response issue, the response to the appeal issues. The first appeal statement, number one, you see it there on the board. The hearings official failed to consider how development of the subject property could render the current traffic barrier on the Fairway Loop moot and thus inconsistent with the WAP, the Willikinzie Area Plan. Well, first of all, the appellants failed to show how the removal of the overlay has any bearing on the traffic barrier. The overlays have nothing to do with the traffic barrier. We know this because, as shown in the record and in your packet, the imposition of the traffic barrier was done without a land use approval. So if you look in the record, in 1999, I believe, the City Public Works Department installed a traffic barrier specifically to address the concerns of the neighbors, basically the cut-through traffic that was utilizing that road. So the traffic barrier is a public works issue. It was not imposed as part of a land use action. It was imposed as a result of discussions with the neighbors and Thomas Larson, the project manager for Public Works, and that's in attachment E of your packet. So logic dictates that if the traffic barrier was installed outside of the land use arena, then a zone change will have no bearing on the barrier remaining. Again, we're not proposing that the barrier be removed, and the zone change has nothing to do with that. So the Willikinzie Area Plan proposed action number 5 on page 97 of the Willikinzie Area Plan specifically directs the closure of Fairway Loop to through traffic between Southwood and Eastwood lanes. The WAP does not suggest that a quasi-judicial zone change such as this would have any barrier on the barrier remaining. So, what am I saying? Well, the Willikinzie Area Plan itself suggests that the barrier be included, which is what happened through a process, not through a quasi-judicial land use process, but through some other process, which in this case was administrative. The hearings official was correct when he stated that on page 7 of his decision that, quote, in any event, any future effect on the traffic barrier is not relevant to the zone change request. However, Mr. Thayer, one of the appellants, suggests that the hearings official failed to consider the issues raised by Mr. Thayer. However, not only did the hearings official consider them, he appropriately held that, quote, the requested zone change would have no effect in and of itself on the traffic barrier. And that, again, that's page 7 of his decision. The appellant's statement that the planned unit development overlay is, quote, and this is important, necessary to ensure that the property is developed in a manner that does not allow a bypass of the traffic barrier and that is consistent with the WAP, is simply not supported. The WAP simply does not have that level of detail for the closure of the street. It simply suggests that as a proposed action that the street be closed to through traffic. The installation of the barrier achieves this proposed action. What the WAP, this is very important. What the WAP does not do is impose upon an adjacent landowner the obligation through a PD overlay or through any other land use mechanism to further discourage traffic. And Althea, would you show the zoning map? It'll show the vicinity. So on the right, you see the subject property outlined in red. which currently is subject to the PD overlay. And the suggestion is that this zone change application is not consistent with the Will-Kenzie area plan because if you remove the PD overlay, you remove a public process that could somehow impose a barrier on Fairway Loop. Okay, well, the barrier's already there. If that were true, if that's really what the Will-Kenzie area plan said, then the property that's adjacent to Fairway Loop on the left or on the west that's zoned R1, which currently is a golf course, but as we know, golf courses don't always remain undeveloped or developed only for golf course purposes, that does not have an obligation. There is no, as far as I'm aware, there is no overlay imposed that would do what the appellants say the PD overlay does for the subject property. So you can't have it both ways. You can't say, well, the PD overlay achieves the goals of the Will-Kenzie area plan because it's imposed on that property, but not have it on the mirror image part of the property on the other side of Fairway Loop. It's simply that's simply not how the Will-Kenzie area plan operates. So the second, then you can go back to the, Althea, if you would go back, please go back to the appeal statements. If you go to the second appeal statement, it's very similar. The hearings official failed to address how development on the subject property could conflict with the Will-Kenzie area plan traffic requirements in the area. And this is where the appellant goes to the specific language in policy 1 of the Will-Kenzie area plan on page 97. And that, the suggestion is that the hearings official erred. And specifically, the appellants argue that the PD overlay is the process whereby the transportation network within the Will-Kenzie area shall be planned and designed. This is simply not how the Will-Kenzie area plan or land use and transportation planning work. Policy 1 is a general policy geared towards legislation or administrative actions for transportation planning. It does not impose a mandatory criterion upon individual landowners to achieve that policy. The appellants assert that the PD overlay is, quote, necessary to, quote, ensure that the property is developed in a manner that does not allow users of the commercial portion of the property to enter and exit the property through the existing neighborhood, and that it is consistent with the Will-Kenzie area plan. However, the WAP itself makes no such claim. And no claim, and there's no support within the Will-Kenzie area plan cited by the appellants to support that conclusion. And I've read through it, and I can find no support. And then the third appeal statement is simply, a conclusion based on the first two. The Will-Kenzie area plan must be amended before the zone change can be granted. Well, if it was truly inconsistent with, if the zone change application was truly consistent with the Will-Kenzie area plan based on a specific mandatory policy, then perhaps that statement would be true, but we know it's not true. So in conclusion, the hearings official did not err in removing the PD overlay. The Will-Kenzie area plan does not require the subject property to have a PD overlay, and nor does the PD overlay ensure that the traffic barrier will stay or be removed. It's on property that is not owned by the applicant. We could have think it through. We could have a planned unit development application wherein an applicant makes an application to develop the property under the criteria of the PD overlay zone and still not have the ability to cut through traffic with the barrier. The barrier could be removed the next day. It's not up to the applicant, and therefore it has no bearing in this application. The applicants respectfully request that the Planning Commission, should the time come, make a determination that the hearings official did not err and adopt the hearings official's decision in its entirety. And at this time, I would like to reserve time for rebuttal and ask that the record remain open for additional information. Then I'd like to confer with my client to determine whether or not, determine how much time would be necessary to again chew gum and walk at the same time and hopefully come to a settlement with the neighbors.
Thank you. The next person that signed up is Rob Bannon.
I'm happy not to sit by myself here. First thing I'd like to do
Can you
is...
just state your name and...
I'm Rob Bennett. My address is 980 Willamette Street, Suite 200, Eugene, 97401.
Thank you.
The first thing I'd like to say is that the gentleman that Mr. Jaworski referred to at the Cal Young Homeowners Association, the elderly gentleman, is right here. Well, so I don't want to speak too long, and I really appreciate the chance to speak. We've been involved in this property for many years, and I think what we've learned over that time is that if you live in and around a vacant piece the size that we have, which is in this case around 7 acres if you consider all of it, nobody likes change. I mean, even if you're a person who believes in compact urban growth and a balanced transportation system, infill development, a little higher density that we all have to accept, anytime somebody proposes something that hasn't been there for a long period of time, it's difficult to accept the potential change. In this case, none of my neighbors objected to a reasonable development project. I mean, they realize that there's going to be some additional density there. They agree that it's a potential mixed-use development site. And so, the issues around that just aren't there. And, while I'm not a technical expert, most of the important issues that the original planned unit development overlay was intended to address are now already covered in the code. So there are good reasons to have planned unit development overlays. I spent some years on the Planning Commission myself. I spent some years on the council, and I spent many years very close to the city. So I am not unfamiliar with planned unit development projects and why sometimes they're important. They're not important here. And what they end up doing is taking a great deal of time at a very high expense. And if you're going to do that, you should have some really good reasons to do that. And there aren't good reasons here. So what really comes out of this then is the traffic issue. Everybody has said the same thing. The last thing we do is remove the barrier. First of all, we'd get lynched in the neighborhood. But more importantly, it serves a very important purpose. I mean, I've lived in the neighborhood most of my adult life. And at one time or another, there were 2,500 cars a day circumventing the Oakway-Coburg intersection and using this as a way to go get north. So the arguments for a barrier are sound. We would never want to remove it. What we do make the case for, though, is being part of the neighborhood. We do not think we are pass-through traffic. Our project, our land is part of the neighborhood. So we are asking to be able to move the barrier so that our traffic can go north of the barrier. And we will have some traffic, but we are part of the neighborhood, and we are entitled to use the neighborhood streets just like anybody else who lives there. There is a current concern about pass-through traffic through a project we might develop. The worst thing that could happen to us is to have pass-through. Can you imagine having our project with the interior streets and maintaining them and trying to anticipate their use and having a bunch of people come through the traffic? No. So We're not interested in having pass-through traffic, and we'll do everything reasonably possible to prevent it. Can I guarantee that nobody will ever cheat? No, but I can guarantee you that even if we had to put up a gate, which I hope we never do, we are not going to allow pass-through traffic.
Thank you. At this point, I have nobody else signed up in favor. And I don't have anybody signed up in neutral position. So the next person would be the opposition, and that would be Alan Thayer.
Thank you, everyone. My name is Alan Thayer. I'm a business lawyer in Eugene, and I am here today as the attorney for the Cal Young Neighborhood Association, and on behalf of myself personally, because I am a neighbor, at least in the neighborhood of the subject property, and a former neighbor of Mr. Bennett, who I hold in great regard and have tremendous respect for both Mr. Bennett and the projects that he and his family have developed. This issue before you is unique. We're not arguing that the applicant shouldn't be able to develop their property. And in fact, that property has sat idle for a long, long time, and understand the need to develop that property. We're not arguing about the traffic that will be generated by development of that property. But instead, as Mr. Bennett recognized, what we are concerned about is how development of that property could result in a return to the days where regional traffic would go through residential neighborhoods to try to speed up their trip and avoid the Oakway-Coburg Road intersection. There is I believe that the barricade was installed sometime after March of 1998. I did see, and it is in the record, a letter from a city staff person that made reference to that, and in handwritten notes refers to a count of 2,500 vehicles a day going through this residential neighborhood in these residential streets. That was back in '98. And I can tell you that the traffic in the Coburg Road, Oakway corridor is substantially greater. What would those numbers be today? Would it be 5,000 cars a day, 7,500 cars a day? We don't know. The reason, and it is correct that we are not opposing removing the overlay that limited the number of units on the residential portion of the property. They can develop that property how it makes sense within the rules established by the city of Eugene. Our concern is, and the reason why we're opposing removing the planned unit development, is because the way the property is developed could impact, one, the need for removing the barricade, and two, whether traffic could go around the barricade by entering and exiting the subject property. Now, Mr. Reeder said that that is not their desire. They're opposed to that. Mr. Bennett said that's not their desire. They are opposed to that. And hence the reason why Mr. Reeder told you at the beginning that we are in good faith working on a settlement where we can resolve those issues between the parties, and a land use decision may not be necessary. That makes, and there was a prior hearing. I do apologize that we weren't able to complete an agreement between now and then. But I can tell you a number of the key people have been traveling, and it's been difficult. And when one person was in, another key person was out. but I can tell you, working attorneys, Mr. Reeder and I, we've been here to work on this. This situation is unique, but the key point with which I disagree with the hearings official's decision is separating the transportation issues from the planning issues. The Will-Kinsey Area Plan contains both. The Eugene City Code refers to local area plans. It doesn't say local area plans except for the traffic provisions. The way property is developed can affect traffic. The planned unit development overlay allows review of the development of this property to make sure that it is not developed in a way that would either require the removal of the barrier or would facilitate people simply going around the barrier in order to continue on their shortcut. Yeah, it's true. We can't control what happens at the Eugene Country Club. I suspect that will stay as a golf course for quite a while. That's not the issue before us. The issue before us is this property, and there is a tool to address these traffic issues, and that is the planned unit development overlay. This has been I'm a business attorney, so the first time I've gotten in the weeds on land use planning issues. I would like to thank Ms. Sullivan, but I also would like to thank all of you who are in the weeds on these issues all the time. So you have my respect, and if we are not able to get this matter settled, then I would ask that you retain the planned unit development overlay. Thank you.
Thank you. Staff comments on the presentations, and then we will have questions from the commission. No staff comments. Are there?
I guess.
Yes.
Sure.
Always the lawyer has something to say.
In terms of procedural matters, both the applicant and the appellant alluded to waiting on deliberations, have some extension of time for the Planning Commission to make a decision on this in hopes of a settlement. I just wanted to point out that as of now, the city's decision deadline is November 9th. The applicant could choose to extend the time to make the decision by some amount of time. In addition, now that we've had the public hearing, the code requires the Planning Commission generally to make a decision on the application within 15 days, unless the applicant and appellant agree otherwise. So if the applicant offers an extension in excess of 15 days, we would also need the applicant and the appellant to agree that the Planning Commission could take more than 15 days to make the decision.
Thank you for that clarification.
Yeah, preferably in writing.
Yes. At this point, I would just like to make a comment. This appeal has come before us before for a public hearing, possibly. I know for myself, I delved into it and did all my due diligence on it the first time, and then was told that we weren't going to have a public hearing on it. When then this public hearing got scheduled, and I spent a considerable amount of time delving into this and doing my due diligence, and I just feel that for myself personally, I'm ready to deliberate on this action, and I understand that the parties may want to do something, but at this point, I'm ready to move forward and deliberate and come to a decision on this. And so I want them to know that that is my position on this. And I don't know how the rest of the commission feels, but that's the point that I'm at before the first hearing. Anybody else have any questions for the attorneys? Yes, let's go with Commissioner Becker.
First of all, I concur with the chairman on making a timely decision. Hopefully what I'm about to bring up, which is not too major, is within the limits of what we can or can't do. The main point that I got out of the testimony this evening is I fail to understand the delta between what the developer is promising to do and what the residents are afraid that they'll do. There seems to be quite a wide gap. So my concern is I've seen developers promise that their intention is one thing, but it's not in writing. So my only concern really is a trust and verify that it's not a handshake, but it's in writing, if that comes within the code.
Commissioner Jaworski?
Yeah, I have just a question, because it hasn't happened since I've been on here. If we were to make a decision tonight, you're saying that has no effect if they agreed to do something else? I don't understand that part.
That's a good question, Commissioner Jaworski. I'm not privy to the settlement negotiations, so I'm not sure exactly what the parties are talking about. The applicant still has a rebuttal, and so maybe we can hear a little bit more about that if that's something they're interested in talking about. It's kind of a strange procedural posture that we're in, right? Okay. Because right now, what we have heard from the parties is that the appellant hasn't withdrawn their appeal, so the appeal is still on the table. The applicant, at this point, it may change in a moment, but has only given the city extensions through November 9th to make a decision. So right now, we're on track to make a decision. We were being asked to deliberate and make a decision tonight to make sure that we met that deadline. If the appellant were to withdraw their appeal, then the appeal goes away. This whole thing becomes moot. If the applicant offers an extension of time and the applicant and appellant are willing to allow the Planning Commission to take more time to make a decision, to give themselves time to figure out if they can come to a settlement agreement where presumably once that happens, the appellant will withdraw their appeal and you'll never have to make a decision. That's another possible avenue. So it's not necessarily, your decision wouldn't become moot, but it is a funky procedural posture. Does that answer your question?
Okay. Yeah.
Mr. Baker?
I'm uncomfortable with the process. I think either the parties need to extend the deadline and we stop work, or once we go in, we have the rebuttal and we go into deliberations, we deliberate, and they're stuck with the results, and then they could appeal it to further up. But we need some movement on their part, I think, if they're going to extend it. We just need to know that before we go any farther, I think. And again, reiterating what Commissioner Becker said, this should really be held for deliberations, but I think I will. I'll hold it for deliberations.
So just so the parties know, as the commission, the procedure for the commission, the next item would be rebuttal from the applicant, and then we have planned a 10-minute break for us to get our thoughts together about the information that we received during the public testimony. After that, we're going to go into deliberations. So that's our time frame. We're going to hear rebuttal, and then we're going to take 10 minutes to talk about it, and then we're going to deliberate, unless we have some other news. Yes.
Is it possible just to ask a question
about the process?
About like how the city decides who finds out about the meetings?
We'd be happy to talk to you about that after the hearing.
Okay.
Yeah, certainly.
Commissioner Baker.
I just wanted to say, I think the ideal is if the parties could come to an an ex parte determination between themselves to resolve the issue, and this whole issue would go away, then that would be the ideal. From my point of view, I think parties work together, they resolve the problem, it doesn't become a complicated legal matter that's built up to LUBA and the State Court of Appeals. It's a nice, clean way of resolving the problem, because we know what the problem is. There's a different point of view from the applicant and the appellate.
Right. So,
If you don't move into rebuttal right now. So you've got another.
I'm going to make the most unusual rebuttal in the world and invite my appellant to be here with me. So first of all, I want to, again, one of the reasons why I wanted to thank you so profusely for your services, because I know how much time and effort you put into being prepared for these meetings. So, Chair Borowski, I understand your frustration about, look, we already looked at this, and then it went away, and now we looked at it again. I'd like to make a decision. Well, in my experience with, you're in a quasi-judicial position. In my experience in the judicial system, most judges try and get these things off of their docket. So maybe you could, maybe we could elect you to the circuit court, and you could take on a tougher workload. But realistically, we really do appreciate the work that you put in. That being said, the parties have discussed this, and we'd be willing to grant an extension of 21 days to the Planning Commission. So what that would do is that, and we can give that to you in writing, what that would do for the Planning Commission is a couple of things, and for the parties. One, it would allow the parties to come to a resolution, a private settlement agreement, wherein if we come to an agreement, then the appellants would remove their appeal to you. Therefore, you wouldn't have jurisdiction to make a decision before you actually make that decision. What it also does is, if in 21 days we haven't come to a settlement agreement, then that gives you the ability to move forward with your decision. It requires us to make more progress on our settlement agreement. Okay, so we have a date certain out there in which we have to make a decision. Yeah, and I think it's appropriate to share that there's a draft settlement agreement that has been proposed. Unfortunately, one of the key members who has to review that draft is in Hawaii, and so is not able to. We weren't able to come to a resolution today, although we had hoped to do so.
And to Commissioner Becker's point, the agreement is a way to kind of the trust but verified provisions that you addressed, and it is entirely consistent with what Mr. Bennett testified during his comments to you. So that's what we're talking.
The other benefit of extending this to give the parties a further opportunity to come to a settlement is then it obviates the need to go to LUBA, which sucks up staff time and is expense. There's an expense to the city. So if we're able to come to, if you decide not to vote today and you decide to take us up on our offer to extend the timeline, then what you do is you increase the likelihood that the city won't be expending resources that it doesn't have to expend.
Question that I do have then is if we grant that or accept that proposal, you asked that the record be kept open. Would you still like the record to be kept open? Because usually that involves 777. And I don't know what the feeling of the commission is. We would have to make a vote on whether to keep the record open or not. But you did make that request.
I did, and I made the request out of an abundance of caution. I would, if you decide to grant the 21 days, then we would rescind that request that the record remain open.
Other questions from the commission? Commissioner Jaworski.
Yeah, I'd like even, an extension is nice. It's 21 days. It's through Thanksgiving. I have planned vacations. We're having a tough time making a quorum now. I'm just saying that's an issue. I'm back to my initial thing. If we deliberate tonight and make a decision, and they had said that they decide something else later, it's still resolved, right? Unless That's
It's
it.
resolved as far as we're concerned.
Yeah,
I mean, the
so
planning commission can make a decision tonight.
But if we can't decide tonight, I can see taking the 21 days. But if we can, I'd like to try something tonight.
Can I offer a suggestion? One option you may be able to consider, staff would have to let you know if that is true or not, but if I were on the commission, I may want to deliberate tonight and come to a decision that would go into effect only if the parties were unable to settle it between themselves within 21 days.
Is that something that would be legally possible?
It's an interesting question. It's not how we usually do things. If that's something that the commission is interested in pursuing, let's talk about that more. I'm not.
Commissioner Del
I'm okay with granting 21 days. I'd like to voice that I'm displeased because we did prepare for this, and this is the second time that you've delayed a hearing. Understandably, land use processes, it's great that you're pursuing a separate settlement, and I wish that many others went this way. That is remarkable and wonderful and exciting. I'm okay with, like I said, granting 21 days, but please be advised that it has been very difficult for us to schedule a meeting, and we also have holidays coming up. So I don't know if it's possible to extend that a bit just to make sure we have some clearance. And I would also advise you again that I hope that the third time is a charm, as much as I love being here Mondays at 6:30. So could somebody advise us if that's possible to have a longer timeline so we can avoid that issue?
Yeah, the reason why we threw out 21 days was to motivate the parties to actually come to a firm resolution quickly, so that we're not belaboring this issue. However, it was a somewhat arbitrary date. We have till March. We would prefer not to take that much time. I don't think it's going to take that much time, but we certainly do not want to impose on your Thanksgiving and other holidays.
I would hope that the thoughts you've heard voiced today has perhaps put a sense of urgency on you that may not have been there before.
Fair enough.
Commissioner Baker.
I was just going to suggest if it was a 4-week extension and we have a meeting that we plan to have within 3 weeks to make a determination, that would give you your 3 weeks to make a determination. If you don't make it then we still have our week to get together and meet and formulate the final order. So that's what I would suggest as an option to consider.
I think we're willing to do whatever works for you all.
Absolutely. That sounds good to us.
Commissioner.
Yeah, I'm still confused. I was under the impression from legal counsel that if we deliberated tonight and made a decision, that it takes effect whenever it's signed by our chair, and that if this group decides to do something else, they implied that that's therefore mute and they just go into what they were doing. Is that correct? If that's correct, we can either try tonight, and if not, fall back on something else.
Well, if we make it, again, I believe this is if we make a decision, then that opens it up for further appeals up the ladder. Whereas if they come to a settlement...
But they're the only ones that
would appeal.
And if they reach a settlement, then what's the appeal?
Well, if they don't like what we said, they can appeal.
No, but they're going to do their own thing, and if they don't like it, they're going to appeal it anyway. But if they don't reach a decision on the side.
It doesn't
If they said they're going to affect something outside of this, then it's irrelevant what we do and what we do.
Let me comment, it doesn't affect the zoning. If the zoning changes or doesn't change, that still stays, and they still have to meet the Eugene Code regarding it. So that the issue doesn't go away just because we don't, we decide one or another. If we decide one way and they go negotiate to get rid of it, and then the zoning doesn't work for what they had planned, then they're stuck. Then they have to appeal it to get rid of it.
But we're preempting what we're doing. We don't know what we're going to decide if we deliberate it.
At this point, we've heard from are you finished with your rebuttal?
Well, that's a tough call, because if you decide to deliberate and vote tonight, then I would like my rebuttal on the substance. If you decide to give us more time, then I don't think there's anything for me to rebut.
And procedurally, I think for me as the chair and for the commission, I would like to hear all relevant arguments, close the public hearing, and then we will decide as a commission how to move forward with this, whether we're going to act tonight, whether we're going to grant time things. But I don't think that that should be decided during the open public hearing. Does that sound correct to staff and the rest of the commission? So in that case, please continue with your rebuttal. We'll close the public hearing and we'll move on with the process and figure that out.
Thank you, Chair Borowski. I'd be happy to do that. There's not a lot to discuss, but I do want to highlight a couple of things. One is that, yes, although the Eugene Country Club is probably not going to be developed, the point remains that any property that is along that road where the barrier is located, the only property that I'm aware of that currently has the PED overlay is my client's subject property. Okay, and so the provision of the Willikinzie Area Plan that's on page 97 of the Willikinzie Area Plan that's in question can't be interpreted to say that, well, in order to achieve that policy, you must have a planned unit development overlay. Okay, that's the legal analysis of the argument that was made by the opponents, and I'd like you to consider that. Additionally, I don't have an opinion about whether or not you can or cannot look to other provisions of the Willikinzie Area Plan in a vacuum, but again, as I said before, we need to look specifically at the narrow issues that were raised by the appellant. So if you do decide to deliberate and vote, then I would encourage you to focus on those narrow appeal items. And that's the end of my rebuttal. Again, thank you very much for your public service.
Any other questions of commission of the applicant after the rebuttal? Commissioner McClellan.
Just to clarify, Mr. Reader, I believe that Mr. Baker suggested, was it 28 days, yes. Commissioner Baker? Mm-hmm. And if I remember correctly, that is okay to you and your client?
Yes, that works for us.
As well. I apologize.
That is to the appellant as well. Yes, we would stipulate either on the record here, or if you would like it in writing, we can do that as well.
Excellent, thank you.
Any other questions for the applicant? Okay, with that, I will close the public hearing and open up the commission for discussion on what we've heard here, not deliberations, more or less process type of how we want to move forward is where I'm looking to get comments from now. Commissioner Baker.
I want to make a motion so we can discuss the motion. I move that we extend deliberations to occur so that they happen within the next 3 weeks. Well, theoretically, let's say 3 weeks from now, with a final order issued by the 28 days.
Commissioner Baker, can I clarify your motion and make sure I understand? So what I think I heard from the applicant and the appellant, and now what I'm hearing you say, is that you would accept their offer of a 28-day extension. You would move to accept their offer of a 28-day extension with the proviso that the Planning Commission were to schedule deliberations about 3 weeks out, so that there would be some extra time to make a decision should that become necessary.
Well, more to prepare the final order and whatever, so we don't have to decide on the spot and you wordsmith it and on the spot. We can get the day after or what.
Is there a second?
I'll second.
Okay. Discussion on the motion to extend the timeline 28 days with a hearing possibly scheduled for about 3 weeks from now.
I can see a possible problem getting a quorum. Possible. My current employer was gracious enough to give me this evening off, but this is high season for the new job I've started, and there's a possibility that there might be a problem getting a quorum. I said possibility.
Commissioner Jaworski.
Yeah, I prepared for this like you did the second night. I have a vacation. There's the Thanksgiving holidays. I don't, I thought if the meeting is December 7th, that's a critical nice day. a lot of things happened on December 7th. But maybe we could meet then. But you're saying meet a week before, you would not have me then for a quorum, so I don't know what you'll have.
This is one of the issues with this type of a time frame.
We do have a regular meeting scheduled for Monday, November 11th. Are you saying you're out of town?
Yeah.
Not the 11th, the 27th, I'm sorry. 11th is
Yeah,
Saturday.
the 27th, we have a regular meeting
We have a
scheduled.
regular
We
meeting
could extend
scheduled,
it.
which is exactly 3 weeks from
Are you
today.
planning on being?
I may have a hard time being
Is that a day meeting or an evening meeting?
We can also do what we typically do,
It's
which
11:30.
is poll for availability. I mean, we need to have 4 of you to make a decision.
Yeah, it was hard enough to get this one together.
Agree.
Do you have a head?
I think at the end of the day, should not we have difficulty getting a quorum, they've requested those days. So I think they're aware of the risk.
Just a clarification on the motion, it doesn't mean the record is being kept open, is that correct?
As of right now, the request to open the record, I understood, was withdrawn.
Yeah, okay.
Yes.
All we would be doing is postponing deliberations until that date.
I'm kind of wondering why we were here tonight.
City council. Not city council, city councilor.
I recognize there's a motion on the table for a specific number of days. I just wanted to remind the commission that what I heard from the applicant and the appellant was that they are open to a longer extension, if that would be helpful. So I don't know if it would make a difference to the commission if you asked. I would want clarification that they're okay with it, but maybe an extension through the end of January to get us through the holiday season and have some extra time to schedule a meeting if quorum is a concern and folks have vacation planned and there are holidays coming up. That, just as an option.
I'm confused, Mr. Chairman, whether or not the extension is to, we may not need to have a meeting, or that's the only reason I see it. And I'm wondering, why can't we deliberate tonight? If we don't achieve what we need to tonight, then we have 28 days to have a second meeting to finish it. I don't understand why we're waiting if I was also told that if they met on the side at any time, whatever we do is mute anyway. So I'm confused in that regard. I don't know why we have to do it.
Me too.
My understanding is Hawaii, and that one of the parties that needs to sign off of hasn't been able to look at the compromise.
Yeah, but if we voted tonight, let's say we achieved whatever we wanted to do tonight, and we have a decision, it's being drafted for you to sign, guy comes back from Hawaii later, agrees to everything, I was told that it was over then. That's what I
Mr.
heard.
Jaworski, just to clarify. So for example, if tonight Planning Commission deliberated, came to a decision and decided that to affirm the hearings official's decision and remove both of the overlays from the property.
Their outside deliberations may not deal with that when they're looking for an agreement. I understand that.
But it may.
And it may not.
We don't know that. So
Yeah, well, that's their issue, not ours. Ours is, we don't even know what we're going to do tonight because we haven't deliberated. If it gets to that point where you as legal advise us that this could cause a lot of confusions, we can just take a straw poll and we'll know where we are. At least we haven't wasted all night.
Commissioner Jaworski, I'd be really interested in hearing actually the rest of what Ms. Summers has to say just for my personal benefit. So could you continue describing what you were discussing?
I think I'm understanding your question. It may be that I'm misunderstanding it, and you can help clarify it for me if I'm getting it wrong. But I think there is possibly a situation where the Planning Commission could act tonight, and it would be counter to something in the settlement agreement that the parties are working on. And one or other of the parties would feel that then they needed to appeal the Planning Commission's decision up to the Land Use Board of Appeals. If the Planning Commission does not make a decision tonight and the parties come to a settlement agreement, my understanding is the appellant has said that they would then withdraw their appeal and the Planning Commission would never have to make a decision. If you're asking, can you deliberate tonight and hold off on making a decision until later? Probably, but I'm not sure if does it make sense to deliberate on something that you may never be asked to make a final decision on? I think that's what the parties were trying to save you that work by saying, take this extension. We think we can get this resolved. The appeal will be withdrawn. It will never come back to you, and you won't have to do the work of deliberating.
Commissioner Baker.
Yeah, if I could clarify. The issue is, let's say, I mean, there's two possible decisions, right? One is you accept the hearings official's decision. Another one is you decide not to accept it. And if you decide not to accept it, then the property still has these PD overlays that the developer doesn't want. The only way that they can get rid of them once we've delivered our decision, that's the law of the land use code. And they'd have to come and make another application for a change, and then, or take it to LUBA. So, or the other way around, we accept the developer's proposal or the hearings official's determination. It doesn't have any of the overlays, and then they can't make a decision, and then they feel that their only way that they can resolve this is to appeal it.
Okay, at this point, we do have a motion on the floor. There is a possibility of amending that motion. And what I'm going to do is I'm going to do my best at making an amendment. So what I'm proposing is that we basically do Commissioner Baker's motion, but rather than it being date certain of whatever it was,
28 days.
The 28th, we make it January 5th, and that we try to have a resolution sometime in December at a point where a Google poll can go out and we would have a quorum. So that gives them about a month to work on it. But we try and have our deliberations sometime in December that works for the commission, where we can have a quorum. And if a decision hasn't been reached or a settlement hasn't been reached at that time, we deliberate and take action at that time. Does that sound amenable to the rest of the commission as an amendment?
Well, the only thing is, if we were going to meet in December, but some of these people are saying that there's a concern with the holidays. If you said like January 15th.
Well, I think there might be a chance for us to meet. That's why I'm saying if there's a doodle poll, and if we have to, we can. I mean, that gives us 2 months to find a meeting date. I
accept the amendment.
Okay. So now we'll have discussion on that motion, whether or not to postpone.
As I understand, we were granted up to 28 days, which would be December 7th, so I'd like to go with that.
He's saying we.
The only reason I'm doing that is in the eventuality that we can't get a quorum between now and December 7th.
Yeah, but what you're doing is you're extending it past what the applicant said that
they said they're willing to go as far as we'd like.
Point of order. With respect, Chair Borowski, we would like to go on the record by saying, first and foremost, we do not want to impinge on your vacations. So that being said, we accept your proposal, Chair Borowski. So we want to go on the record and say that that's true.
Yes, the appellant accepts as well.
So, is there any other discussion on this motion?
Did you accepted the amendment?
Yeah.
Yes.
And you seconded it, so you're fine with the amendment?
I think we're ready for a vote.
I think so too. So, all those. The other thing is that those parties are going to submit that in writing to the city staff. That would be part of it, and that's. I see head nods over there, so that should be fine. Okay, all those in favor of this motion, raise your hand. It's unanimous. So, with that, I would like the staff to.
So now that the extension has been offered and the Planning Commission has taken the parties up on the extensions, my understanding that the applicant has withdrawn their request to hold open the record, so we also close the record.
I will close the. Is there any objection to closing the record? At this point, I would close the record. Anything else from staff as far as, I would hope that you would convey whatever things happen between the parties and us and trying to figure out the scheduling of deliberations if they are going to be necessary. Commissioner Baker.
Do we need a motion to say we move to postpone deliberations to our next meeting that we would schedule in the next 2 months?
I believe you just made that motion.
Yeah, part of my amendment was to schedule deliberations when it was appropriate for the commission.
All right, then we'll need another motion.
Anything else that staff would like from us? All right, at this point, I'd like to thank the parties and everybody who came tonight. I know that this is a difficult process, and I hope that something can be achieved that is a win-win for everybody. That's always what our hope is as a planning commission, is a win-win for everybody. So if this helped to get us there, I appreciate it, and if not, we will see you in a month. Thank you. This meeting is closed.
Before we go, do we want to try